Good afternoon, everybody. Today is July 23, and today we are doing depositions by Zoom. And I have a fabulous panel of trial attorneys. Shalini Nangia is at Varnum in Washtenaw County, and Jerry Cavalier is at Hertz-Schramm in Oakland County, and we have Shelley Kester all the way up from the north in Traverse City. And they all have various degrees. Obviously, all of them have a lot of experience with depositions, various degrees of experience with Zoom, but that's what we're all here to learn about. And so just to kind of give you a quick overview, we're going to talk a little bit about, family law depositions in the first place and how that might look different or have different purposes now that we're in the Zoom era. And then we'll get into some of the logistics of how to do a Zoom deposition. So I wanted to tell you what the impetus was of this particular session. And I had been requested by some prior audience member, and I apologize, I don't remember who that is, and hopefully that person is here. I better go look it up, because if they're not, we'll make sure they have the video. But they really thought it would be helpful to have a webinar on Zoom depositions. And so I started planning it, and then I saw that Shalini and Julia Perkins had done a ICL presentation. This is pre-COVID, so it didn't have anything to do with Zoom, but they had recently done a ICL presentation on family law depositions. And I think the impetus of that was because there was a new court rule limiting interrogatories, and they also did a mock deposition. So I'm going to give you the link to that. If you're an ICL member, I believe you can watch it for free. If you're not an ICL member, I'm assuming that there's a way of buying it if you want to learn about it, more about just family law depositions in the first place. And it's not obviously touching on Zoom, but I'm going to give you the link to that in the chat in just a second. But I'm going to have Shalini start, since she did go through that process of making that webinar with Julia Perkins, just tell us a little bit about it, and if you have any other comments about depositions for family law cases.
Thanks, Lisa. Yeah, so I appreciate you sharing the link for people. As you mentioned, it was pre-COVID, and really the focus was, with the new court rules, with the new discovery reform, do we think that we're going to be doing more depositions in family law cases than we were before? And my position was that I really didn't think so, because I feel like most cases, if you use the new SCAO personal financial statement, and exchange the information that's required in that, I really feel like most of our cases will probably, that's sufficient information to get the case done. But of course, there are others. But in my view, those cases that we were deposing people in before are still the same cases that we're going to do depositions in now, and those would be your more complex litigious cases, maybe with business owners, if there's a big custody battle going on, and those are the cases that you would do those in. And in our ICL webinar that we did, we talk a little bit about how to best prepare your client for a deposition, and then we also did a few mock sessions, not an entire dep, because they're trying to keep those clips limited, but just a little bit of a snippet on how you might prepare a client or how you might conduct a deposition. So useful tips. Hopefully everybody can go check that out.
Thank you, Shalini. So, some of the reasons to do a deposition in a family law case, as Shalini said, existed before and they exist now. And I think one of the things we've talked about, and I would like Jerry to comment on it if he could, about either preparing for trial or avoiding trial. And I think maybe the avoiding trial aspect is even more relevant today than it was in February. Jerry, do you have any additional comments?
I think we always prepare as if we're going to trial, but as we know, we settle most of our family law cases, the vast majority of them anyway. And I think because of the new court rule limiting the number of interrogatories, at the beginning of the year, I actually did schedule a couple of depositions and took a couple of depositions that I might not have taken under the old court rule. We used to be able to send out interrogatories. If we didn't like the answers, we'd redraft them and send them out as a second set of interrogatories. So at the deposition, you get to ask just about as many questions as you want, so long as you're finished within one day. The problem I found was under the new scenario, COVID situation, was entering exhibits. And I've discovered the way to do that. And I think we might get to that later in the discussion. But the Zoom chat feature allows you to enter them in real time as opposed to providing the exhibits to the opposing counsel in advance.
Yeah, we'll definitely talk about that when we get to the logistics phase of today's webinar. Shelley, did you have any thoughts to share about maybe the benefits of doing a deposition now that we're in this remote era?
Well, I do think that the chance to have everybody be together, I mean, the whole process often is that we're not talking to each other and we're hidden behind the interrogatories and answers, just like mediation when parties come together. The opportunity to have a deposition taken can dislodge the frozen positioning that happens and can be the impetus to get people to move towards settlement and resolution a little bit more quickly. I also think it gives you the opportunity to get an assessment of the other side, just like in every deposition, and to weigh the strengths of how the other side's going to present. Zoom does make it a little less intense. People seem a little more comfortable on Zoom. It's less conflictual, I think. So in some ways, I think
less
it's
intimidating.
Less intimidating, and
except maybe for the technology aspect. Although I really feel like the attorneys, and obviously the attorneys and judges, we've been dealing with so much via Zoom in the past 4 months. I don't know what the level of comfort is for our clients out there. And honestly, I don't think I've had a couple of client meetings by Zoom, but really because I do appeals, it's pretty limited. If I don't know if anybody in the audience or the panelists want to share feedback about are their clients catching up with the technology too, or has that been an issue?
Most of the clients are familiar with Zoom. I think we have the older clients might have a little more difficulty with the technology, but that's always been the case anyway. People are using Zoom for work. People are using Zoom for school. Kids are using Zoom, so parents are familiar with it. There aren't too many people that I've come across that are that technologically challenged that they can't figure out Zoom, at least after the first or second attempt.
And I should mention there actually are other platforms, but I think a lot of attorneys were already familiar with Zoom, and I think the state court, the Supreme Court and the trial courts around the state were given Zoom as an option. So obviously now we're even more comfortable with it because this is just what we're using. So I wanted to ask, Jared, do you have something to add? I
began using a different platform, WebEx, but then it seems like everybody's using Zoom, and
right.
Zoom is the go-to.
And there probably are platforms that are better. So I think here's the thing, and this is a comment that somebody has made before, and I think maybe last week when we had the webinar, Zoom was not made to do an evidentiary hearing. That was not the purpose of it. And so maybe there's something out there that would be better for a trial, but I don't know what that is at this point.
I've heard that Microsoft Teams might be a better platform because I think, what we've learned is, having been at this a few months, I feel like Zoom might be better suited for motions or mediations or even settlement conferences, but anything that involves exhibits or testimony, there seem to be some problems, right? In terms of security, in terms of communicating with your client during that proceeding, monitoring what the witness might be doing outside the purview of the camera, whether they're on their phone, whether they have notes that they're looking at, whether somebody is communicating with them. So these are all the dangers, even in depositions, when we're dealing with witnesses and exhibits. And we will talk a little bit about ways to minimize some of those concerns. But yes, I know we're all very well entrenched with Zoom, but I certainly hope we might look at alternatives, because I think that these hearings and depositions via Zoom are here to stay. So,
well, and that brings up a good point, Shalini. And maybe if you are in a county that you have feedback from, put your county in there. This is the question I have. I've been hearing reports around the state that some judges just aren't willing to do evidentiary hearings via Zoom. I know that there are judges like Judge Tina Yost who's doing them all every day. She's having trials by Zoom. But there are some judges who just don't feel comfortable, and some attorneys as well, that don't feel comfortable with an evidentiary hearing by Zoom. And I've been told various reports around the state that there's some counties and or judges who are basically saying, we're just gonna wait. If you want an evidentiary hearing, we're just going to wait, and we're going to start scheduling those in March or April. We're hoping by then maybe we have a vaccine. So if you are, without ratting out, I'm not trying to get any judge in trouble, but if you're aware of a county where you've heard that this might be happening, that anything, if you need a trial, you're going to have to wait a while, and it's probably going to be sometime in 2021 before it can even be scheduled. You know, throw it on, well, of course, panelists, I would love to hear from you, but anybody else, throw it onto the chat. Let us know what counties that you've heard that report, that there may not be scheduling until spring at the earliest.
I've got a case right now where we were in 7 days of trial, and the court administrator has contacted us to say, do you want to return to an in-person trial, or do you want to do it by Zoom? If we do it by in-person, we don't know when that will be, and we're not even going to give you a date. We aren't going to give you.
That was Grand Traverse?
That was Grand Traverse. In a case with 144 exhibits, and we had been in 7 days of trial, it's just logistically difficult. And it's likely that we will agree to wait, but I think that brings up the issue of, you got to make sure you talk to your client about what does it mean to say, I want to have an in-person trial. How long will that wait be? How long is justice delayed, you know, so that they can make an informed decision.
So here's the question. If you know you're going to, like, you have a custody case, and a lot of the stuff I do is post-judgment. So we have post-judgment litigation happening with some like decision that maybe happened this spring, but they really need a trial that's not going to happen for a whole nother year. And there's a temporary order changing custody.
Right.
Huge problem having a year delay or more. Can we use these depositions, and probably it's going to be by Zoom, can we use them to somehow get the case to wrap it up, to get the parties to settle? I don't know with high conflict cases, but you know, any feedback you panelists have on that? It seems like there's an opportunity, to get things done if possible, rather than delaying for such a long time.
I guess it depends on which side of that temporary order you're on.
Right.
Right. It's fair.
Well, and I think both sides have the issue of continuing costs. As long as a case is pending, there's the opportunity for new issues to develop. Yes, the established custodial environment is getting established. But at some point, everybody's going to need some form of relief. And there is a stress of having your case continue to pen, both cost and the inability to move forward. You meet new people, you want to move on with your life. So the deposition does provide the opportunity, as well as mediation by Zoom, to move forward and make progress and explore some options, and to find other mediators. Maybe your first mediator didn't work, but.
Now, with your situation, Shelley, I think it's really interesting. You already had 7 days of in-face trial. That, to me, might be the situation where the parties and attorneys might be willing to transfer it to Zoom, because now the judge already has, maybe from seeing the parties, and maybe they've testified by this point at least once, he might actually, or she or she might have a sense of credibility issues, and how the case is going. Of course, I don't know anything about your case, but that might actually be a case, if it could be wrapped up in a couple days by Zoom, it might be one that would be worth doing. There's other issues if the judge has never really seen the person face to face. I don't know, that there's an issue I have with that.
I think that's a good point. Every case is unique, right? So in this case, a client is concerned that there's an easier ability to be in cahoots with your lawyer, or to lie, or to have the experience of testifying in person it would be unfair for that one party to have testified in person under the pressure of in-person deposition, as opposed to the more relaxed setting of Zoom. Something would be lost. And I think that that's a concern for the client, that really it's important that the judge have the opportunity to see him sweat in court and read the demeanor in a more full way. So that's an issue in that case. I get the point. And this is one of those very, very difficult cases that must have a trial to resolve, unfortunately. So
that was one of the issues that we discussed, was, can you compel a party to a deposition face to face? And it seems, based on some of the judges that I spoke to, at least in Oakland County, they're not going to force or compel a witness to testify face to face under these circumstances, not at least until the numbers reduce in this area. I don't know if it's any different in Traverse City.
No, I think that's the case, that I have not seen a court in Northern Michigan. In Kalkaska, a judge was willing to require at a PPO hearing in-person attendance, but when issues of one of the litigants being a caregiver for their elderly parent, the court said, well, the lawyer could attend by Zoom, but the petitioner had to appear in person, and eventually that resolved by a status conference phone call between counsel and the court. But she would have required in-person attendance in Kalkaska. In Grand Traverse County, Judge Power had a use of a school gymnasium and ran a hearing with in-person attendance in a criminal case. In the family law cases,
a jury trial.
That was a jury trial in person at a school gymnasium with social distancing. Yeah.
Well, it's interesting because I know, I mean, this has been going on for some months, and we did look at some case law, and I thank one of our summer associates, Julia Kosnick, who put together some information for us. And I don't know, Lisa, if you're going to provide any of those summaries, but there is some case law that's come out on this topic, mostly in federal court that we found. There's a handful of federal district court cases, Michigan, Illinois, I think California, New York, Louisiana. But the trend seems to be that they're not going to compel people to attend in-person deps. And I mean, these cases were specifically on depositions, but I assume the same would be maybe for a hearing as well. And one of the ideas that a couple judges had mentioned was that, you know, in person, you're going to be wearing a mask. And if the whole point is trying to assess a witness's credibility, then wearing masks inhibits that. The other, you know, I think some attorneys tried to make arguments about delaying until the pandemic is done, because then we can, you know, go ahead and have it in person. But at this point, I think we don't know when the end of the pandemic will be. And so judges aren't willing, some judges, I guess, are not willing to delay their cases to ensure that you can do it in person. And I think the attorney's preference to be in person does not create enough of a prejudice to overcome, I guess, the risk that's being, you know, created by COVID. So I think, you know, some of the judges mentioned we're in a new normal. So I guess we're having to adjust our expectations and preferences in this new normal. So now this is the trend from cases that have come out, you know, up until now, and I'm sure that will perhaps change, but it seems to be that judges may be a little bit more cautious, at least for the time being. Just like anything else, depends on each individual case and judge, I suppose.
Matt Katchik, I saw that you posted a comment about a case that just came out of Warren District. Is that something you want to just quickly tell us about?
Yeah, I was recently, they convened a special meeting of the Macomb County Bar Association yesterday evening to report on it. And basically what happened was Friday, they had realized that somebody had been tested positive with COVID in the 37th District Court. And what the concern was even though it was found out Friday, it was not reported to the lawyers on that day. So all the lawyers that had attended court in Warren on Friday went home for the weekends to their family members, and they could have been either asymptomatic or possible carriers. And this is the type of thing that definitely concerns me in this era.
So that there's probably a news article about that if you want to attach it as an exhibit to your motion, or your objection to the subpoena requiring you to appear in court or whatever. Okay, or have your client appear even at a deposition. So Shalini mentioned a few of maybe the problems with doing a deposition by Zoom, right? And I think you touched on a couple, but I think there's a couple more that we were brainstorming about the other day. I think you said one of the things you talked about is not being able to see who's in the room with the client or the witness, right? And that's obviously a problem we've talked about over and over again. When we talked about evidentiary hearings, when we talked even about mediation, we don't know who's in the room. And I thought maybe Shelley had a story about.
I have a war story
from a war story, yeah.
Court. So I'm in an evidentiary hearing and I'm listening to the direct exam, which was a very long direct exam covering a myriad of issues. And as the party is answering their attorney's questions, I see him flipping over a piece of paper and I can see question and answer. It looks like that the party is reading a script of their direct exam. And so I couldn't believe my eyes, which I had no idea he was looking at anything, let alone a script. So objected. I wish I would have made more of the moment than I did. I was just so surprised that that would be happening. And so the judge admonished him that he shouldn't read anything but that's an issue for future cross in that case, I'm sure, when I finally get my chance, if we don't resolve it. But there's no way to prevent having somebody do that. And so Lee Hornberger's a peer of mine in Traverse City. He has been doing Zoom mediations, and he gave me a number of questions, you know, sort of threshold questions that I should have asked, or the judge should have asked, in terms of instructions before you begin exam by Zoom about, you know, is anyone in the room with you? Do you have any documents in front of you? Instructions about not consulting? Do you have any communication?
And all those questions apply to depositions, right? I mean,
exactly. So it could be as you do your initial deposition, introductory instructions about, are you on any medication, to kind of go through the guidelines of how. And so one of the questions was, do you have a communication program open, message, messenger, WeChat, Signal, WhatsApp? I mean, who knew? We never had to think about that before, but there's just a multitude of ways people can get communicated to.
Shelley, would you, and I don't want to distract you while you're trying to answer questions, but is that something you'd be willing to like put his questions in the chat, or?
Yeah.
Okay,
yes,
so I want to ask you a question, everybody watching today. Can y'all see right now that I'm looking at my phone, my cell phone, looking at the text message from my client? What he's asking me to, no, you can't see that, can you? Can you see that I'm looking at papers that have questions and answers for me as a witness? No, see? So it's like so easy to pull the wool over the eyes, right? Another thing was somebody else made this point. I'm sorry, I don't remember who it was, but there was an issue about body language and reading your deponent if you're the one that's examining them. Would any of the panelists like to comment about that?
Well, I think that's the problem with having a remote deposition, that you don't get to see the witness as closely as you do if you're in the same room with them. I think it's important for us as trial lawyers to judge the credibility of the witnesses, just like it is for the judge to judge the credibility of the witnesses, and the judge can't do that on these remote hearings. The lawyers can't do that on the remote depositions either.
Well, I mean, I would say to some extent, you know, if you're sitting as we are and you're looking at people's faces, you do have the opportunity to, I think, look pretty closely at someone's face, but you don't get to see, yeah, their body tics, or if their leg is, you know, shaking. I mean, what you could see in full person. So it's a little bit trickier, but there are some judges have said that they prefer the ability to like directly stare at someone's face the entire time, as opposed to in a courtroom where they might be, you know, sitting further away or distracted from something else going on. So I guess there's a little bit of pro and con in that, but generally I think the consensus seems to be that people prefer in person, but we're also not able to do that, especially as we said, if you're in person and wearing a mask, that takes away a lot of the in-person assessment that we would want to do.
So I was going to make a comment. Oh, so you know how sometimes people won't look you in the eye, which is really hard to do. Like right now I'm looking at the camera, so technically I probably am looking you in the eye, but when I'm looking in the camera, I'm not looking at everybody else. So there's going to be something less there. And I think, Shalini, you made a comment about Zoom is better suited to motions, right? With, you know, not evidentiary trials, but motions, mediation. And then, of course, here we're talking about trials and depositions being a little bit more difficult. And Shalini, we're almost done with this part of the session. We're going to move to the more logistics. We have some questions in the chat that I definitely want to bring up. But Shalini, you had an experience with an expert witness deposition by Zoom, and I just would like you to share that with everybody.
Well, yeah, so that's been the only Zoom deposition that I've conducted, and I thought it went fairly well in terms of, I mean, it was like a pretty finite issue, and it was, you know, two experts that pretty much know what they're talking about, and this was the deposition of my expert, and it was a little bit easier because there wasn't really a whole lot of communicating going on. I mean, we didn't, it wasn't something that I was giving a lot of input in because it was mostly my expert answering questions. We, in that case, did share exhibits about 15, 20 minutes before the DEP started electronically so that everybody had them. But I know there's a concern about providing, you know, documents in advance because you don't want the other side to necessarily see where you're going and be able to prepare. So we didn't really give them that much time, and there were really no surprises, I suppose, in this case, because we all know the finite issues we're talking about. But I could see in another case where that would certainly be an issue. We did communicate with each other during a break via email or text, which is something that has been brought up. You know, how do you communicate? But there's a danger too in that you don't want people communicating via text and email during the deposition, because what if it's your client's deposition and, you know, who's emailing and texting the deponent information at that time? But my experience, I thought went really well, because it was such a simple and kind of a clear-cut thing, and we all knew each other too. So I don't think there were any of those dangers that people have been bringing up. But
well, yeah, with an expert witnesses compared to a fact witness, it makes a pretty big difference, right?
right.
Yeah. Okay. Any last thoughts on this? You know, benefits, pros, cons of Zoom depositions before we move to the logistics, Shelley?
I like the fact that, you know, when you have witnesses out of town, that you would have to make a request to the court in advance of the hearing, 7 days in advance, to have a witness appear by phone due to distance. Now, what I'm doing in an abundance of caution, because you never know if Zoom's going to fail, right? So I'm still writing those letters saying, in the event that we cannot attend by Zoom, these are my witnesses that I'm requesting be allowed to testify by phone. Otherwise, they'll attend by Zoom. Because I was trying to decide, do I need to do it? Maybe I don't need to ask permission for or telephonic appearance.
You're worried about Zoom failing because there's an internet outage?
Right, exactly. So I've been in court hearings where the court technology failed. Oftentimes they're adjourning those hearings, but if they decide to go to phone testimony because everybody's there and they need to get it done.
Well, if you're already in person, the example you're giving, this is an in-person event, right? So aren't you going to have to send a letter to have that person testify by Zoom and or phone? I mean,
in the old days, I would have to write a letter and ask permission 7 days in advance for somebody to attend by phone. In the Zoom world, I theoretically wouldn't have to, but what if Zoom fails and the court has to use an alternative means? Then I've missed my 7 days. Maybe I'm better off writing the 7-day letter.
I'm sorry, is that a local rule or is that in the Michigan court rules?
I think that's in the Michigan court rules in terms of requesting 7 days in advance to have somebody appear by phone, telephonic testimony.
Got it. One thing that I thought of is there a cost savings for the client when the depositions by Zoom, particularly with expert witnesses?
I mean, that was definitely a factor in my case, because my witness didn't have to travel. So that saves some time, that saves some expense. And for those of us who, you know, on Zoom like to be, you know, half dressed and half in our PJs, there is that advantage too, I suppose. But yeah, I think that the cost factor is relevant perhaps for some clients, but I still think that probably, you know, I don't know if it's enough to defer people's opinions that they would rather do it in person, but that I guess is an added bonus that you're not paying.
And one of the things I thought of, you know, this would not be for cases that have been going on and you already had your witnesses all laid out, but what about for the cases that are just starting? Now, do you have access to expert witness all over the country that maybe you never would have looked for the witness in California because that would have been cost prohibitive, but if they can attend by Zoom, maybe, I think my suspicion is, whether it's deposition or trial, courts are going to be more comfortable with this idea of people attending by Zoom, which they weren't comfortable with before. And so even if we're talking about a trial that's at the end of 2021, when we're back in person, a court may be more comfortable having an expert witness appear by Zoom. I don't know if it just opens up the door to having experts from other places and giving you more variety. Jerry?
That's true. I think remote testimony is here to stay. So that's why we need to get comfortable with the technology.
So let's switch to the logistics of Zoom, and we kind of we have a little bit of an outline just to help us go in the order of the process. And the first topic we wanted to talk about was the scheduling of the depositions. And one thing that occurred to us is that not all court reporters may be doing Zoom. So I guess I know Jerry's familiar with the company. If you know of a company that's specifically already comfortable doing Zoom depositions, put it in the chat to share with everybody. And maybe if you know, like if they're only in Oakland County, let us know that too. Jerry, you said you knew of a company that's doing them?
Well, US Legal, formerly Bean in Stock, is doing the remote testimony, whether it's a deposition or And then Carroll Court Reporters, formerly known as Macomb Court Reporters, Matt Carroll. He's very familiar with the remote deposition technology and techniques. And then Esquire Court Reporting. Those are the three that I'm familiar with that I use. I've used them for depositions in the past. I haven't used them all for remote depositions during this COVID period, but I've contacted them all and they all use the remote technology. There's also a company called Steno.com, or Steno, S-T-E-N-O, who coordinates the admission of the exhibits that you intend to admit, whether it's an evidentiary hearing or a deposition. And Steno will organize the exhibits, return them to the person, the attorney taking the deposition, and then they'll be at the fingertips of the attorney to forward the hyperlinks to the opposing counsel and to the court reporter. So they're admitted one at a time during the deposition, as opposed to in an early evidentiary hearing, I forwarded all my exhibits in advance to opposing counsel. Well, then they have a roadmap of where I'm going to go in this hearing. Evidentiary hearings, we frequently have to do that anyway, but depositions, we don't. So you don't want to necessarily telecast. This Steno service will organize them in hyperlinks that you just push through the chat button on the Zoom app.
Oh, neat. Shalini, I think you made the comment the other day about how, and I think we're getting this just from the number of court reporter companies we're hearing about, they're actually more adept and more comfortable at this point doing Zoom depositions than, than the judges are with doing the trials. And so they might actually have answers, like if you have to do a deposition, your court reporter might be a good resource for the logistics of it.
Yeah, I think for those people who are doing this for the first time or new at it, you might not think to use the court reporter as a resource, but they've certainly sat through so many at this point. They can probably assist you with how to handle deposition exhibits, how it works best procedurally. So I think, yeah, don't forget to use them as a resource when you're trying to figure out how you want to arrange your deposition.
They're the experts, and they will offer a dry run if you're doing a deposition for the very first time. They will do a test run with you in advance.
And even pre-COVID, they were doing remote video depositions. You'd have to go to the court reporter's office, but you could do video deps remotely pre-Zoom.
So earlier we had a chat question from Matt Kabliska about whether we need to have a court reporter present during the Zoom deposition or whether they can just, we can record it and they can transcribe it after the fact. I have my own thoughts, but before I jump in, I wanted to make sure any of the panelists, if you had thoughts about that process and how it would work.
Well, I still think you have to have a court reporter participate. Somebody has to swear in the witnesses.
And I think there are requirements under the court rule in terms of preservation of the record that you need to comply with court rule, which specify that.
So one of the big reasons I think we should have a court reporter present during the Zoom is because sometimes the audio is not perfect. Sometimes people are pausing, they don't realize it, but their equipment's pausing or they're not articulating enough. And if a reporter is just watching the video, the Zoom recording, they're not gonna be able to stop the witness and say, Shalini, you need to repeat yourself because I couldn't understand what you said. And you might lose critical testimony that way. And maybe nobody heard it. I mean, maybe nobody understood what the person said, or it's at least not gonna be part of the record for whatever purpose you're gonna use it, whether you're using the deposition or trial. So, Shalini, I don't know if you want to take a vote too, but right now I think 3 of us think that we should have a court reporter present in the Zoom.
Well, I guess I would ask a question, and that is, could you use like a videographer, for example? Because what if one of the concerns that people had in terms of coaching of a witness would be if the attorney was coaching or if they were reading from a script, and so could there be a situation where maybe the attorney and their client is in the same room and then there's a videographer so that you can actually see, I guess, both the attorney and the deponent in the video shot? And I'm asking the question, I guess, is the videographer then able to swear in the witness, or do you have to be a court reporter to do that?
So the court rule talks about the mechanics of video conferencing and that it has to be conducted in accordance with the standards published by the State Court Administrator's Office when you're using video conference technology. So I think you're going to maybe need to.
Okay.
Moving to, Jerry touched on this a little bit before, but I think we need to have a little bit more of a conversation about the use of exhibits during a Zoom deposition. I think Jerry mentioned a reporting company who will put the exhibits together for you, give you a hyperlink that you can then click on during your deposition to have everything neatly organized. I know other panelists have other ideas of how to be effective as much as possible. Shalini, do you have any comments about sharing exhibits, using exhibits during the Zoom deposition?
Well, as we've said, that's probably one of the toughest components of doing these Zoom depositions, and I think we're trying to become more creative about it. The password, the URLs are helpful if you wanted to do that element of only presenting them as the questions are being asked. Another technique is also to use password protected PDFs. And one advantage of that, as opposed to the URL, might be that the people could actually download the document, because that's part of the problem with this technology is you get bogged down sometimes if there are technological problems as you proceed. And so if you have a URL and people aren't able to download, the PDF could be downloaded in advance, and then you would just provide the password to everybody on the Zoom, either verbally or in the chat or by email, to open the exhibit when it's needed during the deposition. That's helpful. I know we talked a little bit about the screen share option, which we've even used, within these webinars that we've been doing with you, Lisa. And I think that is also a solution, although I will caution you, and those of you who have tried using screen share, it can be tricky. You should definitely practice this before you start doing it. I've had situations where, there's so many documents that might be open on your screen, and you have to be careful because you don't want to share the wrong thing, obviously, during a deposition. A lot of us keep our emails open, and so, if you have your inbox open, you certainly don't want to project that as your screen sharing. The other thing that's really becoming clear as we do more and more of these situations is oftentimes attorneys may have dual screens. So right now I'm able to look at you guys, but I have another screen if I needed to look at a document. But does your deponent have another screen? That might be something to address before you start your deposition. If you know you're going to have exhibits, see if that can be arranged, because it's really important to keep that visual component and the ability to see the document. And then, I've heard of people providing the, exhibits manually in binders, but again, most attorneys are leery of providing those exhibits in advance. So while that might work for a trial or evidentiary hearing situation where judges often require you to exchange exhibits anyway, in a deposition, it takes away that, element of surprise. So probably find some technological component of this that you're comfortable with.
So I have a question about the comment you made about password protecting documents. Are you envisioning like just a package of documents that are all under one password? Or are you envisioning like each document or small groupings of documents being all separately password protected so that you're not giving the deponent too much advance notice if it's a long deposition, for example, and there's a lot of documents?
I would envision that each document is password protected so that you can open it as and when you need to. And you've emailed it to them in advance, and they just have to know which document to go to, and you just, like you said, put it in the chat. That's a really good idea. I have a comment about the share screen, because we have talked about the share screen. We've used it too in the webinars, but we've talked about it a lot. And I think that what we walked away with from the evidentiary hearings by Zoom is that a lot of people, including the judges, did not want to use the share screen. The judges wanted to be the ones controlling the share screen, but not to have the attorneys using it. And there were a lot of reasons to do it, especially for privacy reasons. When you're in a trial or even in a motion hearing and everything's being broadcast on YouTube Live. But we don't have that problem with depositions because depositions are private proceedings. So I think
depositions would be a very good way of utilizing the share screen, you know, if you don't have too many documents and it works out for your case. I'm guessing it's going to be a case-by-case basis. Shelley, have you done them before with the Zoom?
I've played around with the share screen and the different ways to be careful about what comes up on your screen. So I use a practice management software, and we use Practice Master tab. So in that setting, our documents are organized by the type of document. So I created a tab which was trial exhibits or opposing parties trial exhibits, and I could go to that tab and restrict what was on the vision, and it would only be the listed exhibits. Alternatively, you can embed a PDF into a document where you can just click on the PDF embedding by going to the Insert tab and hitting Object and creating from a file, browse to grab the document you want, and create it as a icon in your document so that you can just open it. You could even forward that document and not lose the PDF. And that's another discrete way to be able to control, when you're screen sharing, what's going to open up. But I agree with you. I've had a trial where the judge wanted to control the share screen, and I had a planned presentation and couldn't present the document the way I wanted to because the judge was deciding whether or not it was going to be open or not. Alternatively, I've forgotten that I've left my screen share on because I don't see it the way other people see. And so I had an exhibit that was sort of gnarly that I left up unintentionally because I had just forgotten about the screen share. And I think I was irritating the court because I had this like bloody shot that I had forgotten about. So there are some dangers you have to remember to turn it off too.
Really good point.
You're not really looking at it. Yeah.
So I'm going to move to a different part of logistics, but if you have a question specifically about exhibits, raise your hand or put something in the chat. I don't want to, these exhibits are a really important part of logistics of depositions by Zoom. So until we see somebody raise their hand or put themselves in the chat, the next thing we want to talk about was attorney instructions to the deponent. And I know Shelley has already posted a few things based on Lee Hornberger's advice for his mediations, which apply equally well, I think, to depositions. Some really good instructions that we should take note of. Let's talk a little bit more about the communicating, the deponent communicating with the attorney during the deposition. Jerry, do you have some advice about that?
Well, a remote deposition is no different than a deposition that you take face-to-face. If a question is pending and you're not on a break, the deponent has to answer the question before they can communicate with their attorney or anyone else. So I think it's important to make sure that you control the deposition, you control the question, you control the timing of the answer before they communicate with their attorney. And that includes, as we've already discussed, electronic devices. You want to make sure that there aren't any electronic devices that they're communicating with any third parties or aren't any other persons in the room. And you ask them that question in advance as a preliminary question. And if you later discover that there are, then it goes to their credibility. So,
Shalini, did you have something to add about the communications? I think you mentioned it earlier.
Just, I mean, as Jerry mentioned, you kind of have to make the ground rules clear, I think, up front, because it's so easy to just have your phone out. As you mentioned, none of us could tell right now if one of us was on our phone. And so, but again, you make the rules clear and you make them known up front and you hope that they're done appropriately. But I know, you know, Shelley shared her experience where even though she called somebody out on it, I mean, they continued, it seemed like they continued to go ahead and read off their script. So unfortunately, our business is such that we have people that don't always follow the rules. And you know, at that point, I guess you have to see if you need to make a motion with the court to strike someone's testimony.
I've done that, yeah. Motion to strike.
I still have those tools available. I know we're trying to keep our clients out of court, but if they're not going to play by the rules, then they don't leave us much of an option, do they?
Any of the panelists have a comment about using the chat function during depositions?
I think that if you're setting, maybe as the person in charge, you might want to disable the chat function during a deposition.
Because they could use private messaging without you knowing about it?
Exactly.
Jerry, did you have something to add?
Well, you need a chat function if you're going to admit exhibits one at a time through the chat. and it's important that you're comfortable using that feature.
Um,
That's one way to avoid having to give them the exhibits in advance.
Is there a way, and I'm sorry, I should actually know this, but is there a way that only the administrator can use the chat function? So like the person who's taking the DEP could then use it to broadcast the password or whatever, but that's the only person that can use it. Does anybody happen to know the answer to that question?
I don't know the answer to that, but I do know that the court reporter can control the exhibits. They're not all admitted, but the court reporter may have the exhibits in advance and distribute them as requested.
So as I was about to put in all of those rules or the introductory suggestions for finding out what they have in front of them and giving them the lay of the land, I realized that I could only copy and paste a certain amount of information, unless perhaps if I had a link. So I think there might
you mean into the chat?
into the chat, right?
Okay.
It wasn't that I could just dump a whole bunch of data in there, unless I had maybe a link that would let me do that.
Got it. I guess I want to talk about privacy issues a little bit and using the depositions, the Zoom depositions to protect privacy. And I think that kind of moves us to the last segment where we're going to talk about using the depositions at trial if we get there, whether the trial's in person or by Zoom. But I think the privacy issues really come up in the Zoom context so than anywhere else. I mean, do the panelists have any thoughts about using depositions in lieu of live testimony at a trial to protect the parties, you know, if there's mental health issues or medical issues or whatever?
I think that question contemplates that we're submitting the transcript to the trier of fact as opposed to calling a witness to read the transcript. Is that right?
Right.
Okay. So,
or potentially to watch. Well, we'd still have to have a transcript for the record, but potentially a judge could watch the proceeding, but there'd have to still be a transcript for the record.
then the trier of fact would have to make the exception that the witness is not available. And I think we're probably moving in that direction.
Shelley or Shalini?
My thoughts on the video, you know, controlling how the video deposition comes across and using that efficiently. It's like anything, you have to familiarize yourself and get comfortable with it. You're going to potentially have objections to what part of that is being played. But it's a new world, and how different courts maintain their records too is another issue. So while you'll have your deposition transcript and your recording of that, it just depends on the circuit that you're in and the court's familiarity with technology. There's a lot of things we don't control. And I think maybe having a planning meeting with the court about how you're going to do that would go a long way. Maybe talking with opposing counsel and trying to figure out how to streamline things. It's a brand new world. And I have yet to see Zoom deposition transcript used in a hearing. I think it's going to take a lot of planning.
Well, I think as Jerry mentioned, though, you do have to also just keep in mind, are we doing this because the deponent is unavailable? Because, you know, how a deposition is conducted and what you may ask might be different than what you would ask at trial, right? And I mean, in a deposition, you're asking all kinds of open-ended questions and you're trying to get as much information as possible, maybe, whereas if you were cross-examining a witness, you're certainly going to ask different questions. And you also obviously have the ability during a hearing to rehabilitate your witness, where in a DEP you don't. So, you know, I don't know that you might get both sides to agree to use a transcript unless it was absolutely necessary for some reason.
Right, because of unavailability, for example, right?
Right, but otherwise one side may not be in favor of that. And if it means delaying it until your witness is available, or if it means doing Zoom testimony as opposed to in-live testimony, I mean, I think the court would probably consider those options unless both parties are agreeable.
Peter Conway made a good point about depositions, and some of them are discovery depositions where others are defending essay depositions. And that might affect obviously how they're being used at trial and everything else. Panelists, do you have any comments about that, the differences and how they might play out with the Zoom?
I'm sorry, I was reading the chat and I missed the first part of your question.
There's actually been quite a few chats. What we're just talking about the difference between, Matt has an answer.
I'm sorry, I missed
Matt. the difference between discovery depths, and I think Shalini was getting to like asking all these open-ended questions, and they can go in all kinds of directions, versus Deponent essay depths. And I think because we're talking about using them at trial, and obviously there's gonna be a difference of how they're used, but right, thinking specifically about a Zoom deposition, is there a difference of how it's going to be used at trial if it's a discovery deposition versus a Deponent essay deposition?
I don't see a difference. I mean, it's a trial deposition. It'd be just you're conducting your trial ahead of trial, and it seems like it would be the same. You have the same logistical issues of exhibits and cross-examination and the weighing the demeanor of the deponent. But I think it's very similar to a video deposition, Deponent essay deposition of an expert. So I don't see a lot of difference.
So I have a question, and I'm not expecting everybody to know an answer, but so I was on the court reporting board of review for 8 years for the state of Michigan, and the body that governs court reporters, but it does not govern videographers. And is there like certification requirements for a videographer to come in, or is a videographer always on top of the court report? Like is an add-on to the court reporter? You have to have a court reporter, and you can also have a videographer.
I don't know the answer to that question, but I do know in my experience, a videographer has never sworn in a witness. Court reporters are able to swear in witnesses.
That's a key distinction, Jerry. Thank you. So that brings me to my next question about using the Zoom deposition to cross-examine a witness about a prior inconsistent statement. So I'm guessing in a lot of depositions of videographers, at least in the family law context, I'm thinking there's not a lot of use of videographers. If I'm wrong, please tell me. But I think videographers are used a lot in other types of cases, like personal injury or commercial litigation cases. But now we have this thing, a Zoom deposition, and do you think it's going to have some added value to the clients if you get to cross-examine a witness, not by giving the judge the transcript of that deposition excerpt, but just say, hey, judge, let me show you this testimony. Or you're showing the witness. You're showing the witness their prior inconsistent statement when they're on the Zoom stand. Any thoughts about using the steps for prior inconsistent statements?
Very powerful. I think it would be very intimidating and very powerful, very impactful.
So I had one more question about, but I see some stuff on the chat, so I don't want to miss anything. And we were talking about, in the traditional world, when you go to trial and you have a deposition, maybe the witness is not available. You have people who are reading it out loud to the judge. Are we at a point now where the judge, could just, I guess, basically just watch the portions of the deposition, rather than having people who aren't the actual people who are talking in the deposition, just like, Jerry reading the part of the attorney and Shelley reading the part of the deponent for those portions, which is obviously a very fake environment, because that's not really the people who are talking. Is there a way to, again, just having an advantage to our clients by having the Zoom deposition available because it's been recorded, like today?
Well, in our cases, the judge is the trier of fact. I don't think it makes a big difference whether they see the video or the transcript, but either way, the transcript of the video has to be purged for objections that are upheld. So you've got that issue of cleaning up the transcript still.
Yeah, I mean, I think, we have this medium and we're using Zoom for all these purposes, but I think we have to remember that the court rules are still the court rules. And, even a lot of times I think we might assume that a deposition these days would be done via Zoom, but I think practitioners should also remember, when you're sending out a subpoena, I mean, it's still going to indicate that there's a date and a time. And I think you should definitely indicate that it's via Zoom, because even though it might seem absurd to think, oh, I'm not going to go somewhere, during this time, during this pandemic, the subpoenas are still the subpoenas. They are still ordering you to appear. The court rules are still the court rules, and the use of a transcript or the use of a deposition testimony hasn't changed, or the judge is still going to make the same decisions. So I don't think that the use of the Zoom during the pandemic is necessarily changing any of our, I guess, trial practices in that sense.
You know, that raises a good point. The same advice we give to our witnesses and clients when they do an evidentiary trial, or they show up to even to a trial court hearing, about how they dress. We've heard lots and lots of reports of people dressing inappropriately for court. And I actually was on a court hearing yesterday, and I was just an audience member. And there was a lot of people there because it was a hot issue that a lot of people were following. And this one guy showed up without a shirt. And then I think he put his shirt on while he's there. I mean, there was a lot of people on, but I could see him because he had the video on. Then there was this exotic dancer that came on. So I think just remember, even if you're in your deposition, you should lock down your room to avoid anybody coming in that doesn't belong there. And then also advise your client about appropriate court decorum. Even though it's not court, it's still like a significant legal proceeding and needs to be taken seriously. Shelley and Jerry, I know Shalini, you just gave us some good closing thoughts. If Shelley and Jerry have anything to add, I'd love to hear from them as well.
Well, with respect to the remote depositions, we used to do remote depositions, but that was when one person was across the state perhaps, and there would be a room full of people in one end and a person taking the deposition in the other. The videographer might be in front of the deponent. Now we're talking about fully remote depositions where everybody's in their own room, and some people aren't capable of the technology. I think it's important to do a test run of the deposition a day or two before, so you're familiar with the program and you're familiar with the equipment, so you're not fumbling with it on the day of the deposition.
Talk with your client about whether or not they want to be with you at the time of the deposition when they're being questioned, or if they want to be remote. Make sure you plan ahead, plan for what could go wrong. Mm-hmm. Do a drive-through run on when you're accessing your exhibits. It's easy to get sucked into the document in your screen sharing, and it doesn't flow as easily. So one of the things that worked for me was to highlight the hard copy, so I knew ahead of time where in screen sharing I would go, so that I wasn't reading the exhibit and getting it monotonous as I was going through the exam. So some of those practical things really are important.
I wanted to note, Sandy Glazer made a really good comment in the chat about a judge wanting to see the Zoom instead of a transcript. And I think that's if it's a short thing, it's like an excellent way of them viewing it. Just make sure it's part of the record somehow. Thank you everybody for panelists for coming with us today. I so appreciated your feedback, and I think we all learned a ton, and hopefully that will help Matt catch up with his deposition. Just kidding. We won't be doing another webinar, I think, until September. So haven't figured out what the plan is when life is not going to be back in normal in September, but that's what we're thinking right now. I'm going to take some time off in August. But it's been a ton of fun working with all of you, and thank everybody for coming. And Shalini, you had mentioned the cases. Let's just talk afterwards, because if you're willing to share them, I definitely want to give your firm credit for taking the time to research them. And I think that could be something very helpful to other people if they're in active litigation regarding Zoom issues in their cases. So thank you.
Thanks everybody. Be safe.
Together.
Take care.